Hello, everybody. This is Jacob Stein, and welcome to Sophisticated Planning for High Net Worth Individuals. A couple of words about me. I am an attorney. I practice in Los Angeles, and my practice in a very large part focuses on what I call private wealth. So we work with a lot of family offices, with a lot of high and ultra high net worth individuals in helping them with all manner of legal planning. This includes estate planning and estate tax planning, asset protection planning, income tax planning, structuring cross-border business transactions, setting up all sorts of wealth structures, investment relationships, and the like. And I thought it would be fun to put together a presentation that focuses on these different things that we do for our high net worth clients. So this is a presentation that samples across different areas of the law. Not a very sort of focused presentation as far as the subjects we cover, but it is focused as to its target, which is doing legal work for high and ultra high net worth clients. So if we move on to slide 2, these are the different topics we will cover today. We will spend a bit of time talking about how to structure irrevocable trusts, how to structure them properly. The reason I would like to spend some time on it is because when we are working with high net worth clients, a lot of the planning that we do, whether it's asset protection or estate tax planning or income tax or offshore planning, revolves around using irrevocable trusts. So you have to be like really, really comfortable with irrevocable trusts, with how they work, how do we structure them to retain control and retain flexibility. And that will be our very first topic. And then we'll go into kind of more specific planning aspects. We'll talk about asset protection planning, both domestic and offshore. We'll talk about advanced estate tax planning structures, including planning for the coming exemption drop in 2026. We'll talk about some interesting income tax planning transactions that we sometimes utilize for our high net worth clients. And time permitting, we'll talk about some international tax planning, focusing on structuring foreign investment in the United States and pre-immigration tax planning for high net worth clients. So with that, let's move on to slide number 3 and start talking about structuring irrevocable trusts. So a trust is something that, if you know how to use it, is truly wondrous. You know, we have all grown up, those of us who practice law, and especially those of us who practice trust law, we all grew up with this idea that a trust, especially an irrevocable trust, is something that is cast in stone. It's something that we should use sparingly. It's something where once a client funds the trust, that's sort of a done deal. It's a decision you cannot go back on. And because irrevocable trusts traditionally and historically have been these sort of cast in stone type of structures where we do not retain control, where we do not retain the right to get our assets back, to make changes to the trust agreement, to change the parties to the trust, there's been a lot of reluctance built in, both into the legal system and into our clients, to use irrevocable trusts for planning. So often, historically, if you would look at when do people use irrevocable trusts, it's more that they use them when they have to, not because it is helpful in some way. And I would like to change how you view irrevocable trusts, and I've certainly changed the way I view them, because just like most people, there was a long period of time when I saw irrevocable trusts as something that's a little scary, because there are tax consequences and we lose control. We really have to be committed to this course of action, and we do not get the right to change our mind tomorrow. So how has all of that changed? It changed in a couple of respects. One, it changed because a lot of jurisdictions in the past 20, 30 years have modernized trust laws, right? And they're no longer the trust laws that many of us have studied in law school and sort of grew up with as attorneys. And so we'll discuss that briefly. And second, I think in the past, I would say 10 years or so, the legal community has just come to draft irrevocable trust in a very different way. Right? So for centuries, literally for centuries, we would draft irrevocable trust in a certain way, and it would never change. It was a very static way of drafting trust, and the reason it remained static is because this is how the prior generation of lawyers drafted irrevocable trust. It worked for them. They didn't get disbarred. They didn't die, so we will continue doing it the same way because it works. And in the past 10 years, there's been sort of a loosening as to how we draft irrevocable trust. And with that came a great deal of flexibility, a great deal of retained control over the assets placed in the trust, and just an ease of using them. So let's talk about that a little bit. So first of all, what is a trust? And it's a very fundamental but very important question. A trust is a contractual agreement, right? In its most basic form, a trust is a contractual agreement between the settlor of the trust and the trustee of the trust. And because it is a private contractual agreement, how we draft and structure the trust is really entirely up to us. And I think this is the big sort of aha moment for a lot of practitioners. Trusts are often viewed as something that, like, it has to be done this way. And if you ask why is that, people will say, well, this is what the law provides, or this is how we've always done it. And if you look at the law, if you look, for example, at the Uniform Trust Act, which most states have adopted in some form, the law does not really specify how we have to draft trusts in most respects. The law will provide what are the minimum statutory requirements to have a valid trust agreement. Like, you must have a trustee appointed, and you have to have ascertainable beneficiaries, and there has to be an intention to create the trust relationship, and there must be some sort of stated purpose to the trust. But once you get past these minimum threshold requirements, how we draft a trust, so long as we're not violating public policy or doing something that is illegal, is really entirely up to us. It is a private contractual agreement. And the settlor and the trustee can agree to any sort of terms that they want to for this private contractual agreement. So bear that in mind, really, for the remainder of this presentation, because we will be coming back to trusts a lot in different contexts. How we draft the trust is entirely up to us. And I will tell you that very often when I'm meeting with clients, and they will ask me all sorts of questions about trust, whether it's taxation or drafting possibilities, distribution clauses, this and that, the answer very often will be, it depends. And I'm not trying to be coy. I'm not trying to be sort of the stereotypical lawyer. It depends, because it really does. It depends on us. It depends on how we drafted the trust. And it's really nice that that is the answer, because in that answer lies a lot of retained control. Right? It's up to us to determine how all of those different things will work. It is up to us to determine how a trust will be taxed. It is up to us to determine how the beneficiaries will get their distributions, and how a lot of the different clauses will be drafted, right? So there's a lot of flexibility, a lot of power in that it depends. And second, when you think of an irrevocable trust, a lot of associations are created by that term, irrevocable, right? So usually when I ask my students, what does an irrevocable trust mean to you? They will say things like, well, you cannot get your assets back. You cannot terminate the trust. You cannot make changes to the trust. You've lost control. And turns out that those things can be true, but they do not have to be true. It really depends on how the trust was drafted. And in a traditionally drafted irrevocable trust, and again, this tradition goes back probably to like Elizabethan times, an irrevocable trust will be drafted to say something like, this trust is irrevocable, and it cannot be amended, and it cannot be terminated, right? So if you look at that sentence, this trust is irrevocable and it cannot be amended and it cannot be terminated, this is the sentence where you're losing all of your control. Right? You cannot make any changes to the trust, which is a pretty blanket prohibition, right? You cannot revoke the trust, meaning the settlor does not have the right to get his assets back. That's what revoking means. And you cannot terminate it, meaning you cannot accelerate sort of the distribution of the assets from the trust and terminate the trust agreement. Can't do any of those things. That's a traditional irrevocable trust, hence all the fears that and anxiety that was associated with using irrevocable trust. And if you look at a well-drafted modern irrevocable trust, you will often not find that sentence, at least not in that composition. So nowadays, when we draft an irrevocable trust, we will, instead of saying, and I'll break this out into the component parts of the sentence, instead of saying this trust is irrevocable, we will usually say the settlor has not retained the power to revoke the trust. What is the distinction? When we say that this trust is irrevocable, we take the power to revoke the trust away from everyone, like everyone. When we say that the settlor does not have the power to revoke the trust, we're only taking that power away from the settlor, which means that maybe that power does exist with someone else, right? It just cannot, it does not exist with the settlor. If we are using a trust for estate tax planning, for asset protection, some of the income tax planning we will talk about, we do need a trust that will be deemed irrevocable under state law. And what sort of a provision must a trust contain? What sort of drafting what must we include in this trust agreement for it to be deemed irrevocable under state law? Well, it turns out that all we need to do is to take away from the settlor of the trust the right to get his assets back. Right? So revocable versus irrevocable refers to something very narrow and specific. We're talking about the transfer of the assets to the trust, right? We've transferred our assets to the trust. Is that transfer revocable or irrevocable? Can we get our assets back or not? That's all that we're describing. And the state law provides that if the settlor does not have the power to get his assets back, the trust is deemed irrevocable. And usually for all these planning purposes that I've referenced, that's all we are looking for, that this trust be deemed irrevocable. So the settlor cannot have the power to get his assets back. The state law does not say that this power cannot exist. Right? The power to return the assets to the settlor. It can, in fact, exist. It should, in fact, exist if our client wants to retain some sort of control over the trust. It's just that this power cannot reside with the settlor of the trust, with the person transferring assets to the trustee of the trust. So hence, in the more modern drafting of an irrevocable trust, instead of saying that this trust is irrevocable, we will say that the settlor cannot revoke the trust. The settlor does not have the power to get his assets back. And we will reserve that power in someone else. And why can't an irrevocable trust be amended? Well, if it can be amended, and if it can be amended by the settlor of the trust, well, the trust probably will be treated like a trust that is revocable if the power to amend is broad enough. Or even if it's not revocable, depending on what the power to amend, how broad it is, the trust may cause the inclusion of trust assets for estate tax purposes, or may allow creditors of the settlor to reach the assets of the trust. But again, the power to amend the trust can exist. Like on a global scale, amend the trust. It's just that power cannot reside with the settlor of the trust. So who will hold this power? We commonly refer to this person, to this position that we are creating in the trust relationship as a trust protector. Something that's fairly new to the American jurisprudence. Maybe a concept that I've seen in use for about 10 years, or at least in wider use. And nowadays, the trust protector concept is somewhat ubiquitous. at least in the context of an irrevocable trust, because it is through this trust protector that we are able to, in an indirect way, retain control over the assets of the trust. So again, the settlor of the trust, our client who's transferring assets to the trustee to hold in trust, cannot be the person holding any of these powers. He cannot hold the power to get his assets back. He cannot hold the power to amend the trust or to terminate the trust. But the trust protector, who is someone else, can hold those powers. And the protector does not need to be, let's say, a professional fiduciary kind of a person or a corporate trustee. The protector can be a friend or a family member of our client. It's just that our client cannot, from a legal standpoint, have the ability to control the decisions of the protector, meaning that legally speaking, the settlor cannot force the trust protector to take an action. Right? The trust protector should be able to say no. Right? So the settlor can go to the trust protector and say, hey, I want you to make changes to my trust, and the trust protector should be able to say, no, I'm not going to do that, right? And so long as that sort of a relationship exists, the trust protector will not be deemed an agent of the settlor. And if there is no principal-agent relationship, then the powers of the trust protector will not be attributed to the settlor. And now we have a trust that, as to the settlor, will be deemed irrevocable, whether it's for tax or creditor purposes, right? But that power does exist. And through the protector, our client will be able to retain control over his assets, the ability to transfer the assets back to his name, and so forth. And the trust protector can be imbued with pretty much any power you can think of, right? So we will often give the trust protector the power to change the trustee of the trust, maybe even change the beneficiaries of the trust, change any provision in the trust agreement, change the governing law that applies to the trust, and lots of other different things. And certainly terminate the trust and return the assets to the settlor are kind of the primary powers we will provide to the trust protector. For most of our clients, the purpose, the role of the protector is to allow our client to retain control over the assets placed in the trust. Remember that our clients do not wake up in the morning thinking that, hey, you know what, today I would like to place my assets into an irrevocable trust. I always wanted to do that. Like, no one thinks that way. The only reason clients place assets into irrevocable trust is because it allows them to achieve some other purpose, right? This is simply a means to an end. They're trying to engage in some tax planning or protect assets from creditor claims. And this is just a tool that we're using. So let's make this tool easier for them to use, right? More user-friendly, and draft the trust properly. For some clients, the reason they are using these trusts is tax planning. It can be income tax planning, it can be estate tax planning. But for some clients, the reason they're using these trusts may be to just have more privacy for their assets, or to protect assets from creditor claims, right? Or to set up some sort of offshore ownership of assets. And if that's the case, maybe they do not want to have any tax consequences on the transfer of assets to the trust. And again, when we consider how is the trust treated for tax purposes, the answer to that question is it depends, and it depends on us. We can structure an irrevocable trust that is ignored for income tax purposes, what's called the grantor trust, treated like a disregarded entity, effectively. Or we can have a trust that is a non-grantor trust, meaning it is not ignored for income tax purposes, and the trust will be treated as a separate standalone taxpayer. For gift and estate tax purposes, the transfer of the assets to an irrevocable trust can be a taxable gift, and therefore the assets are now excluded from our client's estate. Or the transfer of the assets to the trust can be ignored for gift tax purposes. It's not taxable, there's no gift tax, but the assets then continue to be included in the client's estate. But we get to make that choice. So even with an irrevocable trust, if we want to set it up in such a way so that there are no tax consequences of any kind, we can do that. No income tax and no estate tax. So I love using irrevocable trust, and I think the concept, the ability to have a trust protector really makes irrevocable trust much more user-friendly. Okay, so let's now take a look at some specific planning that we do for our high net worth clients, and we'll move on to slide number 4, asset protection. And let's spend a few minutes on asset protection. Asset protection for high net worth clients is an interesting thing. So asset protection deals with the area of the law that helps our clients to protect assets from creditor claims. Right, so here we're not yet talking about tax planning, right? It's not that type of asset protection. We're not protecting assets from the tax man. We're protecting assets from plaintiffs and creditors, right? From any ills that may befall our client. And some clients are seeking asset protection sort of last minute, right? So they already got served with a lawsuit, or they already defaulted on the loans, you know, and the bank is holding a personal guarantee against our client, or they got a letter from some federal agency saying, hey, we're going to start an investigation of your business, or what have you. And then they're doing this reactive planning. And we see a lot of that in our practice. But for high and ultra high net worth clients, you know, our family office clients, our Silicon Valley billionaires, the asset protection planning is a bit different because these people are often surrounded by a great team of advisors who are sort of pushing them to do this proper planning before there is a giant lawsuit against them. And because they're planning in advance, right, before there is any claim or a lawsuit, and because the fortune can be much, much greater, the asset protection planning takes on a different tame. But let's talk a little bit about what asset protection looks like. What are goals, you know, what works, what doesn't work, what sort of structures are commonly used, just to kind of give you a flavor of this type of planning for high net worth clients. So one area of concern for a lot of our high net worth clients, especially the foreigners that we represent who are investing here in the United States, for a lot of our high net worth clients, privacy is of paramount concern. Right? They've accumulated this incredible wealth. Sometimes it's multi-generational wealth. Sometimes these are families that have super well-known names that have been, you know, super well-known for over a century, and they are just concerned about the world knowing what it is they have. I don't know if they are concerned about a communist revolution, or they are concerned about some sort of other government taking of their assets, or maybe they're just more mundane concerns, like they have business competitors who may be coming after them. Some of our clients have political enemies that they are worried about, and some just for cultural reasons want to have privacy for their life, and certainly privacy for the assets that they own. So often the sort of asset protection structures we consider for those clients, structures that are just intended to make it more difficult for the world to discover what are the assets that our clients own. And there are a couple of structures that are used most frequently to accomplish this purpose. One structure would be something like a Delaware or a Wyoming limited liability company. In Delaware and Wyoming, we can register a limited liability company on pretty much an anonymous basis. We do not need to include the name of any individual in the registration. And then when our clients take ownership of our assets in the name of that LLC, it's very difficult for a would-be or an existing plaintiff to connect our client to that asset. In addition to LLCs, we will also often use irrevocable trusts, because if we're using an irrevocable trust, and frankly, even a trust that is irrevocable, what will be the name that is on the title to the asset? Well, it will be the name of the trust, which can be any generic name you want it to have, right? So it can be like the Blue Sky Trust, and then the name of the trustee, And the trustee does not need to be our client. The trustee can be the client's business manager or the client's lawyer or cousin or whoever else. So both with trusts and with LLCs, we are able to obtain a significant deal of privacy for our clients. So privacy is one thing, but actual substantive protection is a little bit different. And substantive protection, we are effectively assuming that the plaintiff will know exactly what our client has and how they own their assets, and the structure still has to work. Now, why would the plaintiff know what our client's assets are? Well, for assets like real estate, perhaps this is something that was previously in the client's name, right? The client owned real estate in his own name, which means that his name will always be in the chain of title. And any creditor can run a Lexis search or search through some other database using the client's name, and they will see that at some point in time, this person owned real property, and then they transferred real property to a limited liability company or to a trust. And they may want to investigate that and see what is the connection between our client and that LLC or that trust. So for real property, privacy may be possible, but only if we are mindful of privacy as an objective when our client is first purchasing that property. And then other types of assets, well, maybe the plaintiff hired a really good private investigator. And that private investigator can pull bank accounts, investment accounts, and all sorts of other things. And a really good private investigator, has access to a lot of that stuff. So privacy is great. It's a great objective to pursue, but we still want substance. And whenever we are setting up asset protection structures for our clients, we always operate from the presumption that there is no privacy, at least not in this day and age. Maybe this is something that used to exist, but let's presume that there is no privacy. The privacy shield fails. Protection still has to work. Right? So we want some substantive protection. There is probably a couple dozen different structures that we use to protect clients' assets. So in this presentation, since we have a somewhat limited amount of time, let's go through a couple. Moving on to slide number 5, asset protection with trusts. Trusts are sort of a big cornerstone of asset protection planning, especially irrevocable trusts. If the trust is irrevocable, has a suspended clause, and is not, in my opinion, self-settled, meaning that it should not be self-settled, then the trust is a good asset protection trust. So what do these things mean? Well, irrevocable versus irrevocable we just discussed. If the trust is revocable, then in every single jurisdiction I am aware of, the settlor will be deemed the owner of the trust assets. And if there is litigation, the plaintiff can go directly after the assets of a trust that is irrevocable. So it has to be irrevocable. Every asset protection trust has to be irrevocable. The trust must contain a spendthrift provision, which is fairly boilerplate, I would think, in trusts nowadays. It would be hard to find a trust that does not have a spendthrift provision in it. And this is just a provision that restricts a beneficiary's ability to assign and anticipate distributions. We want to give the trustee as much discretion as possible when it's making distributions. We sort of shy away when we're drafting asset protection trusts from mandatory distributions because that is something that the plaintiff can take advantage of. We want discretion for the trustee in making distributions. And I personally do not believe in self-settled trusts. A self-settled trust is a trust that is created for the settlor's benefit, meaning I create a trust for my own benefit. That is a self-settled trust. So historically, self-settled trusts were expressly by statute not afforded any asset protection. There is a statute that existed in every single jurisdiction that provided that if the trust is self-settled, if the settlor sets up a trust for his or her own benefit, there is zero creditor protection, period. Starting in 1997, approximately, some U.S. states have started moving away from this prohibition on self-settled trust as asset protection trust. And you have offshore jurisdictions that I think started to move away from this back in the late 80s and allowed self-settled trust as asset protection mechanisms. For someone who lives in that jurisdiction, it may be okay to use a self-settled trust, but certainly for someone who does not live in a jurisdiction that allows self-settled trust for asset protection, it is not okay. So I, for example, live and practice in California. California does not recognize self-settled trusts for asset protection purposes, meaning that they're perfectly valid trusts. There's just zero creditor protection. It doesn't matter how you structure the trust. If the settlor sets up the trust for his own benefit, the creditors of the settlor can reach his assets, whatever that retained benefit is, right? Even if we are able to set up a trust in Alaska, Delaware, Wyoming, or many of the offshore jurisdictions that allow self-settled trust, what may happen? Well, what may happen is, first of all, in litigation in a state like California or New York, where self-settled trusts are not recognized for our purposes, the judge may say, well, what do I care about Delaware law? Delaware may allow the protection for self-settled trusts, but we here in California do not. We think that the Delaware law violates California public policy, and we're not going to afford full faith and credit to the Delaware statute. So that's certainly a very strong possibility. Second, in the context of bankruptcy, when you transfer assets into a self-settled trust, there is a 10-year look back. 10 years the bankruptcy trustee has to set aside the transfer of assets into a self-settled trust. And finally, I think that when the trust is self-settled, sort of more as a practical matter, judges are more likely to allow the piercing of the corporate veil of the trust. So we do not want a self-settled trust. I don't believe it's a good idea. Even in those jurisdictions where they are allowed, I would probably not set up a self-settled trust. And given that we can set up a trust for anyone's benefit we want to, and then appoint a trust protector and give them the ability to change who the beneficiary is, why do we need a self-settled trust? So asset protection for our wealthy clients often does revolve around using trusts, and it will be irrevocable trust with these characteristics. So moving on to slide number 7, offshore trusts. So what is the difference between the domestic trusts that were on the prior slide and the foreign trusts from an asset protection standpoint? Well, so perhaps we do get access to more asset protection-friendly laws. There are offshore jurisdictions that have modernized their trust laws to make themselves much more debtor-friendly. But beyond that, it's more of a kind of a practical thing. I've been practicing just in the area of asset protection for about 20 years, and I've handled hundreds upon hundreds of asset protection transactions. And I usually deal with fairly high stakes cases. A lot of money at stake, big, aggressive, well-funded creditors, whether it's federal agencies or state agencies or former spouses, former business partners, big plaintiffs' law firms, big lenders, and the like. Even with that kind of a practice, I have never seen a plaintiff try to pursue assets in an offshore structure. Now, perhaps I have been unusually lucky in that respect, maybe. And I'm certain that one day I will see a case like that where a creditor is challenging an offshore structure that our client has established. Given the statistics so far, and this is a fairly large statistical sample that we have, the likelihood of a creditor going after an offshore structure is exceptionally low. And even if they do go after assets in an offshore structure, the likelihood of success is even lower. So I am, in the right set of circumstances, I'm a big fan of an offshore structure. I do not believe that offshore structures are one of those things that, it works for what ails you. The offshore structures work for the right types of assets. They work for the right types of clients and the right types of situations. But when they are appropriate, they work exceptionally well. And they work much better to protect assets than pretty much anything else we have available. So an offshore asset protection trust will be an irrevocable trust, just like a domestic trust that we have discussed. And we're looking to establish this offshore trust in a jurisdiction that is friendly to debtors. So we want jurisdictions that have enacted favorable fraudulent transfer laws, meaning they make it very difficult, if not impossible, for a plaintiff to establish a fraudulent transfer, and they require the proof of intent for a fraudulent transfer to be beyond a reasonable doubt, which I don't know if that's even possible. And most importantly, we want jurisdictions that do not recognize foreign judgments when it comes to these types of trusts. And our three favorite jurisdictions are St. Vincent, Nevis, and the Cook Islands. We did use Cook Islands for many, many years. We now primarily use St. Vincent and the Grenadines, and have for about the past 10-some years have used St. Vincent. And by the way, if anyone is curious, and want contact information with the trust company we use in St. Vincent or the Cooks, I'm happy to share that. Nevis, we sometimes will use for foreign trusts, but more often than not, we will use Nevis for offshore limited liability companies. These are structures that just in practice have proven themselves time and time again that they work very, very well. Foreign trusts are subject, if you move on to slide number 8, foreign trusts are subject to certain tax reporting requirements. I do not see that this is any sort of an obstacle to the planning that we do for our high net worth clients. They're already probably filing income tax returns that are several inches thick. So these are additional forms that need to be included. These are information disclosure forms just alerting the United States Treasury and the IRS to the fact that our clients have these offshore trusts. Okay, let's talk briefly. We'll tackle a couple of these slides perhaps. Let's talk about the estate tax planning that we do for our high net worth clients. And really, if you think about it, over the past few years, when we do estate tax planning is not to be confused with non-tax estate planning, it really has been limited to the really high net worth clients. So the estate tax exemption for an individual is now around $11.5 million. It's about $23 million for a married couple. So it doesn't leave a large chunk of the population that is subject to the estate tax. But certainly high net worth clients and ultra high net worth clients still need to worry about the estate tax. And on top of this, and perhaps to complicate matters a little bit, the current exemption is expected to be reduced to $3 million per person in 2026. I think it sunsets sort of automatically and goes from 11.5 million down to 3 million. So a lot more estates will become taxable at that point. So what sort of planning do we look to do for our super high net worth clients? It varies greatly. It really depends on what are the assets that our clients have. So, for example, a lot of our high net worth clients have businesses that they own, and businesses oftentimes are great for estate tax planning. One, we may have a little bit of leeway as to the valuation of that business, right? How do we value it? What do we value it today when we're engaging in the planning? Second, businesses may have valuations that go up and down depending on how the business is performing, right? And we may have a business that today is worth $50 million, and 2 years from now will be valued at $200 million. Well, wouldn't it be great to get that $50 million business out of the estate today, right, and deal with a $50 million transfer tax base and not with a $200 million one? And then also for businesses, if they are inside the right types of entities, we may be able to get access to valuation discounts that further reduce this $50 million value, or whatever it may be, by 20, 30, 40%, depending on the structure we are using. One of the most commonly used structures on slide number 9 is the defective grantor trust. And the defective grantor trust allows us to accomplish what is known as an estate freeze in a very tax-efficient manner. So an estate freeze will look to take an asset that we expect will appreciate in value either in the near future or in the coming years. And today, while the value is low, move it out of the estate. And therefore, freeze the value of the estate at today's valuation. So we look to accomplish an estate freeze with pretty much any asset that we expect will have a somewhat significant appreciation in value in the coming time. So this may be real estate, whether it's just straight out income producing property or a real estate development project that our client is pursuing. And certainly businesses and intellectual property may also fall into this category where we expect that the values will appreciate significantly in the coming years. So very often we will, while you can certainly engage in these transactions with mature businesses, very often where this works super well is with a startup, right? Because in its early years, a startup may still be operating at a loss. We are building up to something, but we haven't yet arrived there. So today we can get an appraisal of that business that is fairly low, and using that low valuation, move the business out of the client's estate. And then once the business is out of the estate, then we're hoping that in the coming years, the value of the business will appreciate. Problem is that how do you move an asset, whether it's real estate or a business or intellectual property or anything else, how do you move an asset out of someone's estate? Because moving out of the estate means what? That you either transfer the asset to the younger generation, to the kids, or you transfer the asset usually to an irrevocable trust for the benefit of the kids. And I'm a big proponent of never transferring assets to kids, because that's just often, asking for trouble. First of all, our clients lose control over the assets that they outright transfer to their children. But second, the assets are now exposed to whatever may happen to those kids, whether it's by folly or by accident, right? Kids can get themselves into trouble. They can get into accidents. They can get sued. They can get divorced. All sorts of things can happen to the kids. And if we transfer assets to the kids directly, we're jeopardizing those assets. So I would much rather create an irrevocable trust for the benefit of the kids, do it in such a way so that our client retains control of the assets that have been placed into that trust, right? And just get the assets out of the estate with the proper irrevocable trust. But how do we get assets from a tax standpoint from our client to an irrevocable trust? Well, from a tax standpoint, there are really only two ways of getting assets from our client to an irrevocable trust, or really to any taxpayer. It can either be a gift or a sale, right? In the universe of tax, those are the only two options of transferring an asset from one taxpayer to another taxpayer, by gift or by sale. So if this is a valuable and, let's say, appreciated asset that we're looking to move, then if it's a sale, we have capital gain tax that we need to contend with. And if it is not a sale, then it's a gift, and now we have a gift tax that we need to contend with. Well, imagine talking to your client and saying, hey, listen, let's take this $100 million asset that you have, whatever it may be, and let's gift it to a trust. We will today pay, $40 million in gift taxes, right, because the gift tax is 40%. let's for now ignore the $11 million exemption. And if this $100 million asset will appreciate in value, your beneficiaries will have the benefit of that. And if it doesn't, well, too bad. You paid the $40 million in gift taxes, and it's a done deal. It's a really difficult proposition to sell the client on, but really so important to do. So a transaction structure was developed known as the intentionally defective grantor trust that addresses that problem. And what the intentionally defective grantor trust is intended to do is to allow us to transfer a valuable appreciated asset from one taxpayer to another taxpayer in such a way so that there are no tax consequences. So these are irrevocable trusts that are structured in such a way so that our client does not retain control, where the assets of the trust will be excluded from the client's estate, right? And we cannot gift assets to this trust, because if we structure it as a gift, there will be gift tax to pay. Instead of gifting, we will sell the asset to this irrevocable trust. And so long as we're selling for fair market value, there is no gift tax element to the transaction. But now there is an income tax. What are the income tax consequences of selling an appreciated asset to an irrevocable trust? And it may surprise some of you to know that the answer to that question is that it depends. What does it depend on? It depends on how the trust was structured. Because you can structure an irrevocable trust as what's known as a grantor trust, a trust that is ignored for income tax purposes. It's treated as a disregarded entity. And if the trust is treated as a disregarded entity for income tax purposes, then guess what? Our client is selling that valuable appreciated asset to himself. And when you sell an asset to yourself, there are no income tax consequences. So the IDGIT, the intentionally defective grantor trust, allows us to transfer a valuable appreciated asset from our client out of his estate, and therefore freeze the estate, freeze the value of the estate without any tax consequences today. So it is a very commonly used structure in estate tax planning. The catch with using IDGITs, and really it's the catch with using skins and grads that appear in the following slides that we will not be covering in this presentation just because of the lack of time, and really an issue with all estate tax planning is that we live in a changing landscape. Some of our clients have such exceptionally high net worth that we know that they will always be subject to the estate tax. And some clients maybe are somewhat borderline, where they're close to that cutoff. And we do not know, at the time of death, will they be above or below that cutoff? Will or will there not be an estate tax? And what are we sacrificing when we move assets out of the client's estate and into this irrevocable trust? We know what we're gaining, right? There is no estate tax on those assets. What are we sacrificing? We're sacrificing the basis step up, right? At the time of death, income tax basis usually increases, to fair market value. So what happens if we do all of this planning, we get the client's business, let's say, into this irrevocable trust, this defective grantor trust, and the client ends up dying with an estate that is not taxable? Well, if the estate is not taxable to begin with, then there is zero value from this intentionally defective grantor trust, and the client lost the basis step up on that. And now the heirs are very unhappy with us that we placed the client into this transaction. So first of all, you have to make all the disclaimers to your clients and educate them about the risks and make sure that they make an informed choice as to whether they want the structure or not. And second, you need to build in some sort of an escape mechanism that if in the coming years we see that either the exemption goes up more, which is probably unlikely, but you never know, or that for some reason the client's estate is depleted significantly, perhaps we want to be able to do away with this trust and return the assets to the client's estate so we can regain the basis step up. So we always want to have a backdoor built into these trusts, which again, Trust Protector, Planning and Trust Protector can help us with a lot. The exemption is going to sunset from 11 million to 3 in, I believe, 2026. We also do not know when our clients will die, obviously. We do not know exactly what the value of their estate will be at the time of death. So sometimes it's fairly difficult to figure out, do we engage in estate tax planning? Do we not? Some clients are well below the exemption, and we say, okay, you know what, you do not need an estate tax plan. Some clients are well above, and they will always need one. But the ones who are somewhat close, that becomes pretty difficult. And I guess that's why they pay us the medium-sized bucks, right, to figure this stuff out. Let's move on to slide number 12, income tax planning with DING. So a little bit about income tax planning for high net worth clients. There used to be a day where I could lecture pretty much all day on income tax planning for high net worth clients and cover all sorts of structures and transactions. There were so many opportunities, so much we could do, but not anymore. Nowadays, when we are getting calls from our clients saying, hey, I'm paying all this money in income taxes, what do I do? The answer is, well, there is really not that much you can do because so many of the tax shelters, loopholes, or just, transactions that are tax beneficial have been shut down. But there are some that are still left. So this one on slide number 12, the income tax planning with DINGs, and sometimes it's WINGs and sometimes it's NINGs, is a state income tax play. State is in the state of California, state of New York, and so forth. So DING, NING, and WING stands for Delaware Intentional Non-Grantor Trust, or Wyoming Intentional Non-Grantor Trust, or Nevada Intentional Non-Grantor Trust, or any state that does not have a state income tax intentional non-grantor trust. And the idea behind these trusts is that, if you have a client who lives in a high income tax state, so California, where I live, is over 13% state income tax rate. If the client lives here and he owns his assets directly, California will tax him on the income that those assets generate. And this may be income on the sale of a business, it can be income on the sale of intellectual property, or just income being generated from a passive income portfolio, right, from the equities that the client owns. Well, that same business being sold in Delaware by a Delaware resident would not be subject to state income tax, right? That same portfolio owned by a Nevada resident will not be subject to state income tax. So is there a way for us to take our California, New York, or other state high-tax client and get some of that income sourced to a jurisdiction that will have no state income tax? And the answer is yes, it is certainly possible. So these intentional non-grantor trusts are trusts that are trusts that are separate taxpayers for income tax purposes. And when we spoke about IDGITs, we spoke about trusts that are grantor trusts, trusts that are intentionally structured to be ignored for income tax purposes. Now we're talking about trusts that are intentionally structured to be respected for tax purposes as separate standalone taxpayers. And the idea is that if we can locate the trust in a state that has no income tax, we may be able to source income to that trust. Maybe the trust will now own our client's business, and if the trust owns our client's business, then on the sale of that business, certainly there's still federal income tax, but because the owner of the business is now in Delaware, there's no state income tax. Or if it's a passive income portfolio, there is no income on interest earnings and dividend earnings and the like. So these are structures that have become popular also in the past, I would say, 5-6 years. We're seeing more and more clients, certainly from states like California, New York, looking at these types of structures. There was a recent United States Supreme Court case, I think involving the North Carolina Department of Revenue, looking at how these need to be structured to make it work, and what sort of arguments do the tax authorities make to attack these structures. But if structured correctly, some significant income can be diverted to a no-tax jurisdiction. And similar logic sometimes will apply to offshore structures. Sometimes it may be possible to divert income not just to a state that has no income tax, but to a country that has no income tax, allowing our clients to avoid not just the state income tax, but the federal income tax as well. I will caveat that by saying that is incredibly difficult to do, but there are some circumstances where that may be possible with some proper pre-planning. On slide number 13, just very quickly, I will point out this transaction known as the monetized installment sale. This is something that maybe we do only a few times a year. This is the only transaction I'm aware of that will allow our client to sell a fairly significant asset that has a large capital gain, get almost all of their cash today, like 95% of the cash on the sale they get today, and they do not pay any income tax today. This is a transaction that works. This is a transaction that has been tested. I'm not going to spend any time today discussing it, but I do want to sort of point you at this transaction, because if you do see clients who sell businesses, if you see clients who sell real estate, if you see clients who sell all sorts of assets, this is something that should be considered for the clients. And then in the time we have remaining, sort of the remaining type of planning that we do for our high net worth clients usually will involve international tax planning. And international tax planning primarily focuses on inbound transactions. So even when we represent very high net worth American families who may have businesses, vacation homes, investment holdings in other countries, there's really not that much international tax planning that's going on. But for pretty much every single one of our foreign clients who are buying assets in the United States, who are investing in U.S. businesses and U.S. real estate, entering into U.S. joint ventures, or maybe even immigrating to the United States, a lot of planning needs to take place. So looking at slide 14 and onward, these slides look at how we do tax planning for wealthy foreigners who are investing or moving into the United States. And here are some interesting things to consider. One, a lot of our foreign clients come from either countries or just from the situations that they manage to place themselves in where they pay no income tax. And if they do pay income tax, they are only paying it on income source to the country where they're resident. And of course, as you likely know, the United States is kind of the exception in that the United States will tax who it deems a U.S. taxpayer on their worldwide income. Right? So you do not need to be a resident of the United States to be taxed. You just need to be a citizen or a permanent visa holder, like a green card. And then you can live outside of the United States. The U.S. will continue to tax you. And then even if you have income that is sourced outside the United States, the U.S. will tax you on that non-U.S. sourced income. So these foreign clients come from countries where they are not taxed at all, or they're often just able to structure their affairs in such a way, or it's a very nominal tax, to a country that will tax you on worldwide income, fairly significant income tax, and a very robust and well-developed system of collecting the tax. Right? We call it a voluntary compliance system in the United States, and technically it is. But given that the enforcement mechanism is so well developed, it's really not a voluntary compliance system. So foreigners who invest in the United States are subject to different types of taxes. So the most common type of tax is the flat tax of 30% on passive income. So foreigners invest in the United States and they get paid rents, royalties, interest, dividends, salaries, wages, and certain other categories that are deemed to be kind of passive, steady income. 30% tax withheld at the time of payment. So whoever is paying the foreigner this type of income must withhold 30% and remit it to the United States Treasury. On slide 15, we talk about the fact that if a foreigner operates a business, traded business in the United States, then they're subject to the same tax regime as all Americans are subject to, just same tax rate, same deduction, same tax returns, and so forth. On slide 17, we talk about withholding on the sale of U.S. real estate. And this is a big one. When foreigners sell their U.S. real estate, 15% of the sale price, not of the gain, but 15% of the sale price is withheld by the buyer, must be withheld by the buyer, remitted to the United States Treasury, and then next year used as a credit against tax liability. So generally speaking, foreigners are not subject to U.S. tax on capital gains in the United States unless that capital gain relates to U.S. real estate, and then they are subject to the same 20% tax rate that everyone else is subject to. So FIRPTA is insured to collect that tax by withholding 15% of the sale price at the time of the sale, remitting it to the United States Treasury, and then using it as a credit against the tax liability. And then finally, and this is something that we at our firm do a lot of, pre-immigration tax planning on slide 19. This is a must for every wealthy foreigner looking to move to the United States. Before our foreign clients move to the United States, so much tax planning can be done. We can take all of their assets, wherever they are, and increase income tax basis to fair market value, allowing these clients to sell their assets after they become U.S. taxpayers without any capital gain. We are able to take all of these assets that our foreign clients have and move them out of the U.S. estate before technically there is a taxable U.S. estate, before they become a U.S. taxpayer. And often before immigration, these things are fairly straightforward and very easy to do. But once the client has become a U.S. taxpayer, right, once they exceed either the substantial presence test, meaning they spend an average of 183 days a year in the United States, and it's a weighted average formula that is applied to determine this number of days, or they get a permanent visa status like green card or EB-5, they're subject to U.S. taxation, and then it's too late to engage in this planning. So we very much urge our clients to engage in pre-immigration tax planning, well in advance of them getting either a visa or exceeding the number of days when they become a U.S. taxpayer. And then the last slide is just my bio, but more importantly, my contact information. I always make myself available to those who have listened to my lectures to answer your questions. You are welcome to call me. Much easier, though, is to reach out to me by email, jstein@alliantlaw.com. Alliant is spelled with one L. You're always welcome to send me an email, say, Jacob, I took your lecture or I attended your class. I have a question, and I'm always, always, always happy to help. With that, I'm Jacob Stein. Thank you for listening to this presentation on sophisticated planning for high net worth individuals. We'll catch you guys next time.